We are live now. So we have the match 5A of the Internationalism Global Moot Court competition. For throughout the day, we have had a good deal of matches, and based on the rules of the competition, now we are with the last match of the day. We have the judge, Mr. Manohar Samal, who is a research analyst as well as an advocate, and we will proceed with the argumentations right now. So those who are watching us live on LinkedIn, Twitter, and YouTube, we hope that you really like this match. So I'm quitting from here, and then the honorable judge will proceed therewith. So the applicant side will be available on the screen. You can see the timer on my right, as you can see it, and as it will proceed, obviously, what kind of arguments will come in, you have anything to say, you can let us know by mail at igmcc@internationalism.co.in, and we will definitely address your queries if you have any. So I'll be passing the baton to the judge to proceed therewith.
Yes, thank you, Vivek. I think the applicant can start their arguments.
Thank you so much. So once we are logistically ready, we'll just request the applicant side to proceed therewith. So just give us a minute. I request the judge to begin therewith. Thank you. The applicants can now request the judge for the pleadings. Thank you.
It's just a check. Am I audible and am I visible clearly?
Yes.
Okay. I'll start in 3, 2, 1. Greetings. May the appellant counsel address the bench as your lordship?
Actually, before the International Court of Justice, you are supposed to address the bench as Your Excellency. And considering that there's only one judge, you can call me Mr. President.
Indeed, your lordship. May the appellant counsel address the bench as your excellency?
Sure, please go ahead.
Your excellency, the appellant counsellor will deal with issues 1 and 2 in 15 minutes, and the co-counsel will deal with issues 3rd and 4th in another 15 minutes, and the 5 minutes left are for rebuttal at the end. If your excellency is well versed with the fact, the council will look forward to address the issues raised. Is your excellency well versed with the fact?
Yes, please go ahead with your argument.
Indeed, Your Excellency. The first issue here is that whether the court has the jurisdiction on the issues related to the Treaty of Skytsu. Your Excellency, it is most humbly submitted before the Honorable ICJ that SR, the applicant, has a jurisdiction over the concerned case. The Council pleads to refer to page 9 of the Moot Memorial, paragraph 1. Under Article 35, Clause 2 of the statute, the court is also open to other states, not parties to its statute. The council reiterates itself, the court is also open to other states, not parties to its statutes. Therefore, the dispute between SR and PDRS, the applicant and the defendant, is qualified to be resolved in this court. The second paragraph of the Moot Memorial, page 9, deals with under the forum propagatum rule, if a state has not recognized the jurisdiction of the court at the time when an applicant instituting a proceeding is filed against it, that state has possibility of subsequently accepting such jurisdiction to enable the court to entertain the case. Your Excellency, PDRS herein, the defendant is thus has to accept its jurisdiction to enable the court to entertain the case. Your Excellency, under Article 36, Clause 2 of the statutes provides that a state may recognize as compulsory concerning any other state. Para 2 in the italics page 9, para 3 of the Moot Memorial states, the state parties to present statute may at any time declare that they recognize as compulsory ipso facto and without a special agreement in relation to any other state accepting the same obligation, the jurisdiction of the court in all legal disputes concerning A, the interpretation of a treaty. Your Excellency, if the Council pleads to refer to paragraph 1 of Moot problem, where the countries SR and the People's Democratic Republic of Suba has been mentioned, and in the second paragraph, the Treaty of Skytsu has been mentioned, which is the border demarcation line established between the two countries has been mentioned. The interpretation of the treaty here is clearly the Treaty of Skytsu Peace. So according to the 2 clause A, 2 clause Article 36 clause 2 clause A, the interpretation of the treaty hereby is mentioned as Treaty of Skytsu. B, any question of international law. Your Excellency, international laws are there to prevent the attacks over other countries and to maintain peace and harmony. As per the facts of the case, Your Excellency, the
Okay,
council may
agent,
plead
agent, just give it. I'm sorry for interrupting, but are you trying to state here that the jurisdiction of this honorable court has been invoked because of the compulsory jurisdiction? Because if that is the case, then there is a strict requirement for there to be a declaration in that respect. So the Moot problem seems to be silent on that declaration. So is it your argument that this court has jurisdiction because it has signed some declaration? Because I don't see any sort of declaration here.
Indeed, not your lordship. The council begs to differ here that the point the council wants to put forward is that, as mentioned in the Moot Memorial paragraph 1, that the court is also open to other state not parties to its statute. So clearly, PDRS, who has not given a declaration, also can be a party for this particular case. The council here pleads the dispute between the SR and PDRS is qualified to be resolved under this court, and the jurisdiction is there under Article 36 clause 2 of the statute. Whether the defendant country follow this statute or not, Article 35 clause 2 is open to all parties, all states not parties to statutes.
Okay. Applicant, I want you to note that PDRS is a party to the statute of the International Court of Justice as per the Moot problem. The only thing is that there is no compromise or a declaration accepting a compulsory jurisdiction of this court. So, but still, please go ahead. I won't stop you in this time.
Much obliged, your lordship. If your excellency apologies, if your excellency allows the council now proceed with the same issue and continue with the proceedings.
Okay, please proceed. But for your information, I would like to point out that you are not a counsel when you're before the International Court of Justice. You are called the agent. All right, and your the teammate is going to be called the co-agent. So please do not refer to yourselves as counsels. But please proceed.
Apologies, Your Excellency. The agent will now see to this. The agent, as was mentioning, that third, the question, any question of international law. As the agent mentioned, that international laws are there to prevent the attacks over other countries and to maintain peace and harmony. As per the facts, Your Excellency, PDRS airstrike the SR territory. Your Excellency, the agent pleads to refer to paragraph 7 of Moot Memorial, where last line, where it has been mentioned that PDRS, after the veto vetoed of their draft resolution. They have air striked. So here the agent pleads that the second, any question of international law is thus binding on PDRS. C. The existence of any fact which, if established, would constitute a breach of international obligation. Your Excellency, here the agent wants to plead that the breach of the international obligation is the border demarcation line which was established before the independence of the both countries, and the PDRS, the defendant country, has not been providing this, has not been compliance with the fact that the demarcation line is present, and they have violated the border, they have violated the personal authority of SR government. Thus, since the issues in this case are enlisted above as mentioned, the agent pleads here that the courts has the jurisdiction on the issues related to the Treaty of Skytsu Peace. If Your Excellency allows, the Council will now proceed with the second issue.
Please go ahead.
Much obliged, Your Lordship. The second issue the second issue is whether People's Democratic Republic of Suba, herein as PDRS, has resorted to the use of force when it attacked in the Scythian territory. Indeed, Your Excellency, it is most humbly submitted before the Honorable ICJ that PDRS had resorted to the use of force by conducting the airstrike despite their draft of taking permission for conducting an airstrike on the territory of SR was vetoed by UNSC. For this, the agent pleads to refer to Moot paragraph 7, where in the second last line it has been mentioned that the UNSC has clearly not given permission for the airstrike, and the PDRS, the defendant, has despite not taking the permission, has conducted the airstrike on the territory of SR, the contested territory of SR. PDRS approaches to take the permission of doing airstrike based on some evidence involvement of some private military faction spontaneously killing Gramadan people. Since the draft is vetoed by UNSC members, means there is no seriousness about the same. Your Excellency, the agent...
Can you cite any judgment which explicitly states that the use of force is a violation under international law?
The agent pleads ignorance on this fact, but the agent would like to mention that the Article 30, Article 40, 41 and Article 38 of UN Charter mentions that two countries has to maintain harmony and peace among those countries and should not interfere in the personal internal matters of the other countries.
Fine, please go ahead with the argument.
Much obliged, Your Lordship. Your Excellency, apologies. Your Excellency, the agent pleads to refer to page number 11 of Moot Moot Memorial, its 6th paragraph, where the agent has clearly mentioned that the draft is vetoed by the UNSC members, means there is no seriousness about the same. One SR was the permanent member, and another member of the SR, another member of the UNSC has vetoed the draft resolution given by the PDRS. So they have not seen any seriousness in the military faction spontaneously killing Gramadan people. The evidence lies false here. Your Excellency, on 1st of October, the attack on the PDRS embassy, where they have claimed 5 out of 30 diplomats suffered the damages due to arson and rioting, would be looked into as an inefficacy of the SR government. But Your Lordship, but Your Excellency, apologies. But Your Excellency, the agent plead to refer to paragraph 7 of the Moot preposition, Moot problem last line, where they have been second last line, where they have been that Gramadan community allege suppression. The suppression has not yet been confirmed. They have just alleged that there has been a suppression, and only the some Gramadan people. Paragraph 5, last line.
Okay, so Agent, are you admitting that the government of SR has committed any some sort of atrocity on some Gramadan people? Because you sort of use this some word, that's why. So are you admitting by any chance? Because there
Indeed,
seems to be a discussion about a video in the Moot problem. So a video released by one of the Gramadan women. So yeah,
indeed,
what's your
not
take?
your Indeed, not your lordship. The claim by the women Your Excellency is talking about is Winnie Schroeder, and in the paragraph 7, first line, the SR government issued a statement refuting all the claims made by Winnie and counter claims that the gal who has been involved in the reverse missed. The first question asked by Your Excellency is whether the SR government sees that they are violating the rights of the some Gramadan people. Indeed, not Your Excellency. Firstly, SR is a liberal democratic country, as already mentioned in the Moot problem, first line. Secondly, there has been an election for the democratically elected people. So the election consisted of voting, the proper voting right to vote was there, proper right of fair chance to vote and right to fair chance or representation was there, and the government formed was clearly the coalition
Agent,
government by.
yes, yes. So, Agent, that is in fact an internal matter which is not supposed to be discussed before the International Court of Justice. Your argument should be solely upon the accusations you have against PDRS, or maybe since you're claiming that there is use of force, I would really like you to, give an extremely legal argument about this use of force. So considering that you're the applicant, the burden is currently on you to prove that there has been a use of force. And since you're also claiming that the GAL has been involved in the embassy attacks, but the GAL also has issued a public statement of some sort saying that they are not involved in these attacks. So who's to blame here? Because this is another country's embassy, and considering that there are diplomats being attacked, this does make a big problem for PTRS. So what's your take on this?
Much obliged for the question, Your Excellency. Firstly, the SR government has done a crackdown on the members of the GAL in the coming days, and it has been mentioned in the paragraph of. In paragraph 5th, second line, that the GAL pressure group GAL is subjected to be in high contacts with the officials and industry owners affiliated to PDRS. So clearly, as stated in the facts, Your Excellency, the agent would now plead that the PDRS has been helping the GAL community of the SR government, and then the riots happening in the own country has been due to the PDRS involvement in the for the GAL community. They have been subjected with the high contacts and officials and the industry owners affiliated to the PDRS. Secondly, Your Excellency, when PDRS have when PDRS had
Okay, so
notified.
are you trying to say that the involvement of GAL and PDRS is a violation under international law? Because I don't see where this argument is going. What is your I mean, there must be a certain set of reasons why you've approached this code. Although you've managed to talk about the jurisdiction in some way, I would really like you to focus more on the violation here, and not go move on to the ancillary issues which may not be so relevant.
Much obliged, Your Excellency. The agent here only wants to plead that the PDRS, the airstrike conducted by the PDRS, is not within the is the violation the agent has been talking about. The SR government in the contested area has their own rights, and the PDRS should not have violated the border demarcation line and has contested the airstrike on the people. For the GAL community, in short, the SR government is taking action and is and has not come before the ICJ for the GAL community. Rather, the SR has filed this case in ICJ for the PDRS and to punish their actions for violating the border of SR and PDRS. The agent here only pleads that the PDRS should not have violated and should not have used any misstatement for the SR government, that they are the inefficient to work on the embassies. They are inefficient to form to give them the sovereign immunity under Vienna Convention. So,
Okay, wait. All right, agent. So, are you also trying to tell me that a misstatement is a violation under international law because there is a clear destruction of property which belongs to some other country here? So, do you admit that there has been destruction, and are you willing to pay them compensation for the diplomats they've lost? Because there is no dispute about the fact that there is real destruction and real loss of life and property here. So how would you defend something like this? Because this is what has actually happened, and that's going in favor of PDRS.
much obliged, Your Lordship. But Your Lordship, yes, the SR government is planning to give some compensation to the people who are being attacked. But the problem here in question is that PDRS has attacked the contested territory of SR. What the SR government was trying to state is that they should not have violated that border. They should not have attacked. The SR government was taking action. The SR government has taken down the call for the GAL community, and they have identified that they had been in contact with the PDRS. So ultimately, the SR government here is at loss because the PDRS is attacking with airstrike on the SR government. The GAL community in influence of PDRS is attacking the SR public facility, arsoning and looting, and the word of inefficacy of sovereign immunity, the applicant country would be providing provided the compensation amount to the diplomats and would have taken actions against it. But the time time was not exactly given by the PDRS. Rather, they resorted their force. They could have asked for this. They could have waited a little more longer, but they didn't, and they just rushed to the UNSC, and then they have, without permission, they have attacked the contested territory of SR. And thus, Your Excellency, the agent here wants to say that wants to plead that the SR government is trying to make things right by providing by punishing the PDRS for violating the border. If Your Excellency allows, the Council will proceed with further arguments.
Sure, please go ahead.
Much obliged, Your Lordship. Your Excellency, apologies. Your Excellency, on 1st of October, as mentioned, as the agent was talking, agent is talking about the attack on the PDRS embassy happened in the capital of SR, for which the SR administrators were going to take action. The agent reiterates that SR government administrators were going to take actions and were tracking down the members of the GAL. The official statement of PDRS and the involvement of the GAL within the influence of PDRS has led to this chaos. Your Excellency, suppression of Gramadan community people's civil and political liberties is not true, as it is well known that SR is liberal democratic country. Your Excellency, the agent would like to refer to paragraph 1 of the moot problem, where the SR has been mentioned as a liberal democratic country, and unlike PDRS, which is a socialist regime. So the conversation about the so when the PDRS, the defendant had asked for the protection of the Gal community, for the Gramadan people. It is totally the internal matters of the SR, and they had been taken correctly by the democratically elected ministers, and the country is been ruled by a democratically elected party, a coalition party. When Gramadan people wish to have their separate constitution and parliamentary body, the government of SR did not make that happen, because they believed in the equal rights to be given in the citizens of SR. And due to some of the Gramadan people, this could be done peacefully inside the territory of SR with the internal matters of SR, but the PDRS has violated that. So, Your Excellency, PDRS had nothing to do with the internal matters of the SR government, and they had never adhered to the Treaty of Skytsu peace, and thus they did resort to this was not the last thing they could have done. They did resort to the SR territory and conducted the air strike, after also being vetoed by the UNSC. If your Excellency allows, the co-counsel will now proceed with the third and fourth issue.
Fine, your co-agent can proceed. Yeah.
Apologies, co-agent. Much obliged, your Excellency.
Just checking, am I audible properly?
Yeah, you're audible.
Thank you. Greetings. If Your Excellency permits, the agent would now like to proceed with the third issue.
Please proceed, but a word of caution for your team. Please do not use greetings, because this is not an email or any sort of written communication. So never say greetings in a moot court competition. Apart from that, yeah, please go ahead.
Much obliged. The third issue, as it states, whether the officials of Skythian Republic did not commit ethnic cleansing on the Gramadan people under international law. Indeed, not, Your Excellency. The officials of the Scythian Republic did not commit ethnic cleansing on the Gramadan people under international law. This can be seen through, if Your Excellency may refer to paragraph number 3 of the Moot problem. Some Gramadan people wished for an autonomous treaty, which led them for an irrational desire of having a separate constitution and even a separate parliamentary body. This irrelevant, irrational, and unreasonable demand was denied by the SR government, as the SR is a liberal and a democratic country which considers the equality among rights of all of its citizens, and every citizen is equal in its eyes, which can be clearly inferred from paragraph number 1 of the Moot proposition. Your Excellency, may Your Excellency please be pleased to refer to paragraph number 4 of the Moot problem, which states that some Gramadan people started protesting against the government, the newly elected government of SR. The protest, which was initially peaceful and it was intended to continue to be peaceful, did not continue it. There was a formation of a pressure group known as GAL, and it started vandalizing statues and monuments and the embassies even. At the end of the fourth week, it was seen that 20 people died and 50 were injured by this not so peaceful protest.
Agent, so
Yeah,
see, if there is some sort of disturbance within your country, it's solely an internal matter. Now, coming to the international issue here, there is accusations that there was some sort of displacement where the Gramadan people were sent to a certain locality. What's your take on that? Because that is sort of one of the initial stages of genocide, targeting a certain group and sending them to a specific location. In fact, something like this has also happened during the Rohingya crisis. So, what's your take on this?
indeed, Your Excellency, the issue raised here is that did the SR tried to, for an ethnic cleansing of the Gramadan people, but it can be inferred here that uh, the SR government took actions on the people of the Gal community, but not on the HOC community. But this thing does not mean that it was aiming to remove the Gramadan community people from the country, because HOC did not show anything that caused harm to the Gramadan community or any citizen of the country. This can be inferred from the Moot Memorial, page number 12 and paragraph number 12 as well. If Your Excellency allows, the agent would now like to proceed.
Yeah, please go ahead.
Much obliged. Uh, if Your Excellency may be pleased to refer to page number 12, paragraph number 10. Because of the chaos happening in the country, SR investigated and tracked down the facts about GAL, that they have high contacts with the officials and industry owners affiliated to PDRS. Your Excellency, the relationship between SR and PDRS was not very nice. It can be said that it was constrained, and having a confidential relation and contact like this cannot be justified in any manner. So it can be inferred that
Agent, I'm sorry, but I still don't know how having contact with another country is the problem here. I mean, you you are deviating from the claims you've made in your memorial also. So please stick to what you want as a relief from the court. I think, and please try to cite more legal evidence like judgments or different conventions which both the countries are part of. Considering that in the Moot problem, a lot of conventions were also given saying that both the nations are parties to these conventions. So there is a lot of violation in that respect as well, and nothing has been raised uh, yet. So please try to have a more legal argument. Proceed.
indeed, Your Excellency. Uh, as already referred, the agent would now like to repeat that the draft resolution of the PDRS was for taking permission from UNSC to conduct an airstrike got vetoed. The action taken by PDRS was vetoed. Yet again, it airstrike. So uh, I'm sorry, but am I audible?
Yes.
Thank you. Uh, Your Excellency, as for the legal parts, uh, and under the Article 39, 41, and 42 of the UN Charter, the SR government, the SR went to UNSC on 16th of October 2020 uh, for the restoration, for the with a draft resolution to impose economic and diplomatic sanctions upon PDRS. Yet again, that was vetoed, and now it has moved to the ICJ. Um, Your Excellency, if your Excellency allows the agent would now like to proceed with the second issue.
Please go ahead.
Fourth issue. I'm sorry.
Yeah, please go ahead.
And the fourth issue states whether the People's Democratic Republic of Suba is liable for the attack on the Scythian territory. Indeed, Your Excellency, is liable for the attack on the Scythian territory. In order to conclude this, Your Excellency may be pleased to refer to page 14, paragraph number 13, which states that GAL was affiliated to PDRS uh, and that only incited GAL to attack the embassies and then blame the SR government for the same actions. Same actions. Which can be this can be concluded that all the actions committed by GAL were approved by PDRS and all the things that GAL committed throughout since September was based on the directions of PDRS, and this cannot be justified at any cost, and hence the people.
So, do you have any article or any judgment which says that such sort of collaboration is not justified? Because you've been saying that this type of activities are not justified. So please give me a leading source or reference.
Your Excellency, the agent begs pardon.
Fine, go ahead.
But um, if Your Excellency may be pleased to refer to Moot Proposition paragraph 5, Chai Spora, the political leader of the Gramadan community, is imprisoned by the government of SR on the grounds of malpractices during elections in August and September 2020. Your
Sure.
Excellency,
I
this
mean, you see, as the government of SR can literally do whatever they want internally, but how is this relevant before the International Court of Justice? I mean, you imprison a leader who's causing trouble or whatever. I mean, that's an internal thing. So why is this being brought up before this court?
much obliged, Your Lordship. This topic has been brought up because this might be one of the major possible reasons for PDRS to attack SR. As the SR always considered the Gramadan people of, as PDRS always considered the Gramadan people of SR as the own people. So it can be inferred that if when a Gramadan political leader was uh,
Okay,
imprisoned
so
in
agent,
the
all you're trying to say is that you have an inference and you've come before this court on the ground of an inference, or is there anything concrete here?
needed excellency. The complete part is um, it can be if Your Excellency may be pleased to refer to paragraph number 8 of the Moot problem, which states that the government of SR approached to UNSC for an emergency session called by the United States of America and Russian Federation on October 16 and request in the draft resolution to impose economic and diplomatic sanctions upon PDRS as adhered to the as PDRs, the other country to this treaty, to the Treaty of Skytsu. The PDRs never adhered to this treaty. So this was one of the major reasons for SR to rush to UNSC to plead for the.
All right. See, agent, you went to the UNSC. There is no problem with that. I'm asking you why are you before the International Court of Justice? Uh,
Your Lordship, your apologies, Your Excellency. The agents are here in front of this honorable court to plead and to plead to charge PDRS for its actions and for the airstrike that it committed earlier, and to validate that airstrike, which PDRS has been denying for long. P, Second. PDRS, as the GAL, when GAL committed these actions, which has been mentioned in the Moot problem, paragraph number 4, the actions were approved by PDRS, and it has been it has been creating chaos in the country of SR. So, in order to restore peace, the agents of the applicant country are here to plead and request the honorable court to grant us a proper demarcation line and punish and charge PDRS for its actions.
So, tell me, where is it written that the International Court of Justice can punish or charge a country? Do you have any article that says something like this? Because your relief has to be the relief claimed has to be something which we can grant as a court, and not something which we cannot grant. So, do you know any article within the statute of the International Court of Justice which says that this sort of relief can be given to an applicant country?
Mm. Your Excellency, the agent begs ignorance.
Fine. Okay. So I'm presuming this was your prayer. Was this your prayer?
Your Excellency, the agent would now like to proceed with the prayer again.
Sure.
Wherefore, in the lights of the issues raised, arguments advanced, and the authorities cited, this honorable court may be pleased to, number 1, charge and punish PDRS for its actions. Number 2, order to properly implement a proper demarcation, and or pass any other order that it deems fit in the light of justice, equity, and good conscience. And for this, the applicant, as in duty bound, shall humbly pray. Thank you.
Fine. Respondent, it's your turn.
The agent seeks permission to approach the virtual dais.
Sure, please go ahead.
The agent would like to refer to the bench as Your Excellency.
Sure.
If Your Excellency is well versed with the facts and the jurisdiction of the case, the agent would like to move ahead with the issues in hand.
Yes, please.
And the arguments. If it may please the honorable court, this is the agent Praneet and co-agent. We are representing the respondent side in the case of SR versus PDSR. This case is generally dealt in a 4-4 manner. The issues have been dealt in a 4-4 manner broadly. Issue 1 and 2 will be dealt by my co-counsel, and issue 3 and 4 further will be dealt by me. Handing it over to you.
With the permission of the bench, the agent would like to proceed with the arguments.
Yes, please go ahead.
The agent would like to put forward with issue 1. Issue 1, whether the court has jurisdiction on the issues related to the Treaty of the Sudetu Peace. It is humbly contested before the Honorable Court that the court doesn't have the jurisdiction, and it will be proved in 2 different manners. First, the treaty is not recognized under Article 38 of ICJ, and second, the consent of the parties in respect to the jurisdiction. The treaty is not recognized under the Article 38 of ICJ. According to Article 38, which ICJ states, I quote, the court whose function is to decide in accordance with the international law, such disputes as are submitted to be shall apply first International conventions, whether general or particular, establish in rule expressly recognized by the contesting states. B. The international customs as evidence of a general practice accepted as law. C. The general principles of recognized by civilized nation. D. Subject to the provision Article 59, judicial decision and teaching of the most highly qualified published of the various nations are subsidiary means of determining the rules of law. Considering the present case, the applicant approaches the court on the submission of ICJ. In return, the respondent for the same says that it did not recognize the jurisdiction under Article 38 of statute.
Okay, agent,
According
please, sorry to interrupt here, but please tell me if your country, PDRS, had ratified or expressly signed this treaty when the country was colonized.
Sir, according to the factual matrix, it is said that the PDRS has not recognized itself in the treaty. It has been seen from the time when the treaty was came into the force. According to
Please tell me how a treaty can come into force without there being two parties. I mean, this cannot be a unilateral document which SR government comes out with and says that this is a treaty. I mean, that's not possible, right? For there to be a treaty, there needs to be at least two parties, two or more parties. So this treaty cannot enter into force if both the parties have at least not signed it. And as far as I know, the derecognition part from PDRS came later, but first it all started with violation. The term,
yes, sir.
yeah,
Yes.
yeah.
The agent would like to speak.
Yes, please
Sir,
go ahead.
So, so I'll go with the second sub issue, which is a consent of the parties in respect to the jurisdiction. So, according to the case of Anglo-Irani Oil Company, I quote: the ICG it was stated by ICJ. I quote: the general rules laid down in Article 36 of the statute are based on the principle that the jurisdiction of the court to deal with and decide the case on the merits which depends will be of the parties. In the parties not confirmed, the court lacks such jurisdiction. So, according to the facts which has been according to the factual matrix, the PDRS and SR, they came into treaty when they were colonized, and they had undergone this treaty, which means they were forcefully, or maybe whatever, because it's not been mentioned properly. And after that, from that point of time, PDRS has been stating that I have not been I'll not follow the treaty rules, and has stated the same in the ICJ. In another case of monetary gold case, ICJ refrained from the principle of constitutional basis of the court jurisdiction in the following words: to adjudicate upon the international responsibility of Albina without her consent would run counter its to well-established principle of international law embodied into to the court statute, namely that the court can only exercise jurisdiction over the state with its consent. So, in the present case, the PDRS has not given the same consent that they have been into this treaty, and they are not under the jurisdiction.
Go ahead.
The agent would like to move forward with the issue 2. PDRS has restored to the use of force when it attacked in Scythian territory. According to UN Charter of all the countries to maintain peace among the people and in their states too, there has been a violation occurs in UN has a right to intervene in state matters or any other country.
Okay,
And can
agent, I
also
would like to stop you here because what you're reading says that the United Nations can intervene. You are a country, PDRS, and there is
Yes.
nothing which justifies the use of force. I mean, looking at the collective interest or collective good of the people, you can certainly do that within your own country, but you cannot go and use force in another country unless and until you can show me something which show me a valid ground of this use of force, because that is what is being claimed by the applicant.
The agent would like to prove the same in the further arguments.
Yeah, please.
So in the present case, they were killing of the people, which was it was killing of people by the private military of the majority community in the SR, and it has said the killing of the people and inefficiency of the government had got the respondent to airstrike to stabilize the situation
Okay,
in
agent.
the and
So, see, inefficiency of a government. That way, half the world would have been destroyed, because more than half the entire world is filled with inefficient governments. Does an inefficient government justify the use of force by your country on another country's population? Do you have anything to say on this? Because I don't see anything here. Okay, but still, please.
yeah. The so these are the crimes which is against the humanity, and the commission of sovereign authority against the civilian wardens humanitarian intervention to protect the sovereignty of such state has been violated by the authority. And according to the factual matrix also, the Serpent issued an official statement on October 1st, 2020, that the 5 out of 30 diplomats in the embassy have been subjected to damages due to the arrest and writing, and they blame the
Agreed.
ineffective.
See, agent. So, if you were hearing the applicant's arguments, they're ready to pay you compensation for the loss of life and property in your embassy, right? So, there's no problem in terms of that. I mean, you must have heard that they have already admitted to that, and they're willing to pay compensation. Now, fine, please.
When the
We need not
sovereign
raise.
authority
Yeah.
when the sovereign authorities violate the basic purpose for the which the sovereign power is vested in their hand, by becoming the threat to the citizens life, the sovereign ultimately violate the humanitarian, and therefore the humanitarian intervention is sought and carried on by the people, by the other state, to bring the peace in the same. So I would
Wait a
like to.
minute, wait a minute. So, was this grave violation or threat to human rights done towards your citizens, or was it done towards the citizens of the Republic of SR?
It was done to the citizen of the SR.
So, I still, unless and until you don't give me a legal sort of reference or source which clearly specifies that in such kinds of violation in a different country, another country can use force, I'm not going to be convinced. But yes.
The same was held in the US-led intervention in Somalia and the NATO-led intervention in Bosnia, with the Australian intervention. So these are the places where the humanitarian intervention was done by the different state on the other state. So in the NATO intervention in the Fry, where there was an aerial bombast by the authorities, providing right to intervene.
Agent, I think you should highlight the other two examples more, and not NATO, because NATO is an alliance of countries, and here you are a single country, so you cannot rely upon an alliance of countries for your evidence. You gave two other examples. You can certainly highlight those.
Uh, yes, Excellency. Uh, s- so I would like to highlight the Tanzanian intervention in Uganda and the French intervention in Central Africa Republic, where the use of force was carried out due to necessary substances and the proportionate manner in order to prevent uh, the furtherance of the mass atrocities committed by the government on their own citizen. In the other cases, where there were two countries, USA and UA, they also intervened in Syria in 2001, 2013. So this was also allowed, and further, uh, according to it has been expressly stated in the Constitute Act of African Union, Article 4A H of this act, which provides the right, which I quote, right of the union to intervene in the member state pursuant to the decision of the
Agent,
assembly in
agent,
which.
agency. You're doing the same thing what I told you not to do. So, what is the African Union? African Union is a regional bloc, right? You are a country, like a single country, like a literal single country. So, please rely on singular, and also about this. These types of interventions which you are highlighting as examples. Some of them were permitted by the United Nations Security Council. In your case, the Security Council has also denied to give any sort of permission for this form of intervention, mainly because it was vetoed. So, what's your take on this?
The proportionality and necessity require the attack to be limited in the military objective. So, according what was happening in the SR, where they were ethnic cleansing, so the proportionality of killing the airstrike was only on those people on the private military who were killing the minority community in the SR.
So you're
Uh,
saying there was no collateral damage? There were no civilians killed in this airstrike, because that is next to impossible. I mean, no extremist group is ever going to live in in separate clusters. I mean, they always have human shields and stuff like that. So there was civilian deaths here, and also I am still not convinced about the legality of use of force. But please, you can go ahead. I won't stop you on this now.
The airstrike met. So I would like to speak 3 4 points. The government of SR had used a private military against the government committee. They had been using this force to kill the particular minority community uh, in the state, which is known as ethnic cleansing. There is a good reason to believe the government or SR will continue to use the private military force on going to the civilians in the coming days if nothing was done to stop them. Second, the action of PDRS to alleviate the humanitarian suffering caused by the use of military force by the government at the UN Security Council have been reportedly bought by the permanent members of the council. Disregarded to that, the PDRS has attacked on SR, and when the SR went to the Security Council for the same, it was vetoed out, and no one had objection against it. Further, PDRS used the force in conscience and objective in the charter since it aimed to prevent the human right violation which was taking place. It has no personal agenda behind this. In any event, there is an obligation of the state towards the internal community as a whole to prevent the mass human violation contrary to the international law, which was stated in the humanitarian. It was stated in one of the article of humanitarian intervention. Further, I would like to end. Therefore, the airstrike by the PDRS is justifiable on the grounds of humanitarian intervention, as there was gross violation of human rights on the minority community in the state, and their lives were in danger. Plus, the sovereign was not able to take control on the happening with on the rights and the other things happening in the state. Therefore, the PDRS had to intervene in this matter and take the action for the same. The council seeks permission for the co-agent to speak the other two issues.
Yeah, please.
The
Not
just
very clearly.
just a second. There's some issue with. Sorry.
It's all right. Please. Don't worry. It's still soft, but I think you can go ahead. We'll just increase the volumes for you.
Yeah, am I audible?
Yes. Now you're clearly audible.
Okay. So the agent seeks permission to approach the virtual dais.
You've
Yes.
already done that. You
So,
can like straightforward start your argument.
all right. Okay. So the agent will be further dealing with issue 3 and 4, as issue 3 completely talks about whether the official of SR had committed ethnic cleansing on the Gramada people under international law. So this particular issue will be dealt in a threefold manner. First, we'll be looking onto the interpretation of the term ethnic cleansing under international law and its applicability. Secondly, we'll be looking onto the term ethnic cleansing amounting to genocide under international law. And thirdly, the presence of intention on the side of the applicant in regard to ethnic cleansing amounting to genocide. Now, referring to the term ethnic cleansing, the ethnic cleansing has been mainly been referred in the case of Croatia versus Serbia. The whole case revolved around the whole term ethnic cleansing, referring to the United States of resolution, where the term ethnic cleansing was given an interpretation where destruction or disallocation of national, ethical, or religious groups leads to an ethnic cleansing.
Are
Now,
you familiar
uh,
with the facts of the judgment you're citing?
sorry, the Croatia versus Serbia.
Yes. Are you familiar with the
Yeah,
fact?
so the agent is well versed with the facts of the particular case that has been cited.
Fine.
Uh,
Fine. Go ahead.
um, Good. Okay. All right. So the term ethnic cleansing is in correspondence to the term genocide. So now, as we see in the current case, as we see there is the ethnic cleansing leads to destruction and disallocation. So in the current case,
Just a
as
minute.
Winnie
You
being
said ethnic cleansing can be used as an alternative term to genocide. Is that correct?
not as an alternative, it is a form of genocide. The activities of ethnic cleansing
Any
acts as
legal
a
reference? Any legal
uh,
reference for this?
yes, there is a legal reference, as in the case of Bosnia versus FRY, where in that case there were two contentions which were being led in reference to ethnic cleansing and genocide. So one of the main contentions over here were that the activities of ethnic cleansing, if it amounts to the activities of genocide that have been mentioned under the Article 2 of the Genocide Convention, would lead to a genocidal crime that establishes a genocidal crime. That's how it
So,
acts as a form of genocide.
is it your argument that all forms of ethnic cleansing can be genocide, or are there some sorts of ethnic cleansing which do not qualify as genocide?
Uh, the agent would say that not like all form. It depends. Now, if the activities that are fulfilling the criteria under Article 2 subclause under
So
Article 2 of the
tell me, you've kept on telling me that there is a criteria under Article 2. So state the criteria out as well. What's the
sorry.
criteria?
Okay, so the criteria. Okay, so under Article 2 subclause A, it states that killing of members of a group, of the group. So now this is one of the criteria. Second criteria is where causing serious, uh, torture to the people and mental torture to the people. Now, implying this particular point into the current scenario, killing of the members. Now, as the Gramada woman Winnie had Gramada woman Winnie had contended before the social media post, and it had been widely telecasted that her family members were killed, and this clearly shows that though they were not part of the riots, they were still being harmed. And moreover, in reference to the mental torture, so the mental torture over here, it is clearly mentioned in the factual matrix as well that there have been torture caused to the family members and to Winnie. And moreover, they have been denied access and they were being asked to leave the native area. As the whole point over here is that ethnic cleansing is basically conducted in order to ask the particular sect of people to leave the native areas. Um, if your excellency is
So you're trying to
if
tell me that
the
ethnic cleansing and forcible displacement are the same things? Because what you just said is forcible displacement. And although it might be a criteria, one of the criteria for ethnic cleansing, it itself is not ethnic cleansing. also about the mental torture or the mental whatever part. Uh, there is also a lot of judgments which says that mere humiliation of any kind is not to be considered as mental harm. There has to be something real. So, what is the real factor here, which is causing
So,
mental harm? You've justified
uh,
killing, okay. You've justified there is displacement, okay. What about the mental harm? If you're raising the point, you justify it.
okay. So, in the reference to the mental harm, the nature of the mental harm over here would be that, as in that the mental harm shall be of such a nature that it goes beyond the unhappiness nature or humiliation of a temporary nature. For an example over here, in reference to the current scenario where they were denied access and they were not given access to the public facilities and they were not treated well, and that particularly caused a mental harm to the members of the family and to the Winnie, and as she contested before the social media. And one more
So you're
essential
saying, so
part
you're
of
saying, so are you saying that you conducted the airstrike to like protect Winnie? Because also this brings me to another question: is an individual a subject matter of public international law? An individual like
uh,
Winnie, because this is a
sorry,
public
there was a bit.
international law case. Okay, so is an individual subject matter of public international law, or is it only the states? Because this is a public international law case. Since you're talking about Winnie
It is
here.
it's a case of public international uh, law.
So, all right. So, which is the law of states? So, why is Winnie being spoken about here? Because that's an individual person. So,
No,
my question still
so you
remains.
we need the excuse me. Just a second. There's some issue with the device. Just a second.
Sure, sure. Yeah.
Yeah. Sorry for the technical glitches.
Yeah. So, my
Yeah.
question
Uh,
is you can hear me clearly now, right?
yeah. I can. Yeah. I
Yeah.
can do
So,
it.
is an individual a subject matter of public international law? Because public international law is law of states where two countries come in conflict with each other.
Your Excellency, the agent over here states that it's not only the matter of the individual that has been infringed, it's a matter of a member and a particular community over here. So, as the matter of a community is being in question and is being in course, so it can be a whole question of humanitarian law under the international law. So that's what the agent would like to further plead in reference to the question.
Fine. Please go ahead with
Yeah,
your argument.
the agent would move ahead with the further arguments. Okay, in order to prove ethnic cleansing as a form of genocidal crime, there shall be two elements that we need to take into consideration. First is actus reus, and second is the mens rea. So now actus reus has already been proved where there have been few acts and activities as referred in the factual metrics. It has clearly proved that there is actus reus. However, actus reus is not only the condition that needs to be fulfilled in order to prove genocidal crimes has been established. The main point over here is to prove that there is a mens rea, and the mens rea shall be of such a nature that the intent of that particular community is to destroy the other community. So now, in reference to the current scenario, as the Gramada community being minority in nature, and as again referred as again it has been even stated by the GAL that as referred in the Moot proposition, where the country and has intentionally marginalized the SR government, where it says that the international community, they have been subjected to a part of a country, and they have been institutionally marginalized to the SR government.
Okay, so
This
fine,
so
fine. All
since
right. So see, agreed. Let's say for the sake of argument that there has been a human rights violation in the Republic of SR. How would you justify the use of force, especially when the Security Council has not allowed this form of intervention? If they would have allowed, then this question wouldn't have arisen, or in fact, we would have rejected the allegations of the applicant straightforward. But in this case, the Security Council has strictly denied permission for this form of intervention. Your co-agent was not able to answer this, and that's why I'm asking you now. Do you have anything
uh,
as legal reference which tells that your use of force or intervention is justified, even when the
yeah,
Security Council does not allow?
yeah, Your Excellency, the co-agent, the agent would further move ahead to issue 4 in order to prove the question that has been raised before the co-agent. Alright. So moving on to issue 4, where issue 4 mainly talks about whether the PDSR is liable for the attack on the SR. So in this case, the main contention that the agent would like to bring forward in front of the court would be that the airstrikes that were be conducted on the part of PDSR were as a part of self-defense, as a part of private defense. Apologies for the were a part of the private defense under Article 51 of the UN Charter. Now, the agent would like to refer to two main articles in this current memorial, where one is Article 22, and secondly is the Article 29 of the UN Charter sorry, of the Vienna Convention of Diplomatic Relation.
Okay, agent.
So as
So you said that this was an act of private defense. So the defense was against what? What action of
the
SR led you to be a victim in international law? That led you to because if you're not a victim under international law, you can a victim state. You cannot invoke private defense. So, which were the activities that led you to use this sort of force as private defense?
So, in order to act as a private unit, the activities where the injuries that the harm that was caused to the PTSI embassies in SR, and moreover, the as GAL had relation with the PDSR, they are also being harmed in the country, and
Wait a minute. Wait a
further
minute.
in
All right.
reference.
All right. So you have relation with a terrorist group, an extremist group. Is this what you're admitting here before the International Court
Uh,
of Justice? Because you just said that GAL has affiliations with the government, and nevertheless, GAL, whose citizens are these like extremist groups? They belong to SR, right? I
uh,
mean, they're not your citizens. I mean, if your citizens
yes.
were under attack, then you could have certainly said that. But and please remember, GAL is not some like friendly group or something. It's a terrorist group. So please avoid affiliating yourself as a country with a terrorist group. I mean that is like,
Like,
straightforward. It's frowned upon in international law. But okay, please proceed.
yeah, Your Excellency, Your Excellency, firstly, in reference to the self-defense over here, was basically the embassies that were being harmed over there. Now, I would like to quote the case of United States of America versus Iran, where where the Iran country had not performed its duties, and the U.S. embassies over there also were harmed, and therefore, even in that scenario, this United States of America had acted within the ambit of Article 51 of the United Charters, yeah, under the UN Charters, and further. Where referring to the example of a Libyan England woman had been shot in Libya. She was a part of the embassy, and that's how and that's how England broke its had get ridden of the ties with the Libya, and as there is a prohibition under there is the term prohibition under, there is a term under the council, the agent would like to refer to Article 4, Para 2 of the UN Charter, which says that the prohibition of using force is confined within the scope of international relation. Now, in this case, as the SR official had not performed their duties, and this had led to, and then they had, the PDSR had all the rights to get away with the relations, international relation, and therefore the prohibition is only confined as to the international relations. uh, your Excellency, if if you're satisfied with the arguments, the agent would like to move ahead with the prayer in hand.
Yeah, please move ahead with the prayer.
Wherefore, in the light of the issue raised, arguments advanced, and authorities cited, may this honorable court be pleased to be declared, adjure, uphold that the PDSR the PDSR doesn't come under the jurisdiction of the issue relating to the Treaty of Suzhou Peace. PDSR had resorted to the use of force only on humanitarian intervention when in attack in SR. The SR did commit ethnic cleansing on the Gramada community under international law. And lastly, PDSR is not liable for the attack on the SR. It was only on humanitarian grounds, and or pass any order that this honorable court may deem fit in interest of justice, equity, and good conscience. And for this act of kindness, the counsel for the responder shall duty bound forever free.
Okay, so I have one last question, and also I want to point out something after this question. Does the International Court of Justice have power to deliver an order or judgment in equity, justice, and good conscience? Because we know that this can happen through domestic courts of the common law system. But what about the International Court of Justice? I mean, you're not before national court, right? So equity, justice, and good conscience, right? So question is, does the ICJ have power?
The agent pleads ignorance in reference to.
Okay, so for your information, the answer is yes. There is a legal maxim given under Article 38. Do some further research on that. But there needs to be consensus between both the parties agreeing for this equity, justice, good conscience order. Only then there can be. Since there is no express declaration or compromise here, we cannot do that. Yeah, and please avoid using this equity, justice, good conscience in before an international court in any future matter. So, yeah, fine, all right. So I think the applicants will be given a chance for rebuttal. So please correct me if I'm wrong, Abhivardhan. But I think that's how. Fine, you can proceed.
Your Excellency, the agent would now like to rebuttal the points given by the defendant agent.
See, a defendant cannot be before an international court of justice, okay?
Opposition agent.
Respondent, okay? Just let's stick with respondent since the moot problem has been framed that way. Ideally, it's not even respondent, but okay, moot problems are framed this way.
Much obliged, Your Excellency. So the first rebuttal, the agent would like to plead here that the respondent has mentioned that PDRS had never stated, PDRS has mentioned and stated that they don't want to have the border demarcation line. Although in the moot problem, it has never been mentioned that the PDRS has ever stated that. Though the point they have stated is that SR and PDRS were the under colonial occupation, and they had undergone through a treaty, namely the Treaty of Skytsu Peace, in which the border demarcation line was established. But the respondent country had never clearly mentioned and never stated that they don't that they never agreed to the terms even after the independence. They never clearly mentioned that. Second point, Your Excellency, is the respondent has mentioned the Winnie Schroeder example, for which they have been mentioning that the Winnie Schroeder family has how brutally been tortured by the SR government. Your Excellency, the agent would like to refer to paragraph 7, first line. The
Okay,
SR
so agent, tell me, I asked this question to the respondent, but they couldn't answer it directly. Is an individual a subject matter of public international law? Because this is not private international law, before the ICJ. So what is the answer?
No,
No?
no, Your Excellency.
So
According to
how is this part of Winnie even admissible then, if you're saying no? Ideally, the answer is yes. There are a lot of judgments. You could do some further research, and you'll notice that an individual is also subject matter of public international law. Fine, but please go ahead.
Indeed, not your indeed your lordship, but the agent begs to differ here, that in this case the Winnie Schroeder example has not been has been generalized by the respondent team, respondent agent respondent. The agent clearly has stick to the point that only some of the Gramadan people, and not taking the example of Winnie Schroeder, should be admissible in this honorable ICJ. The point for which the respondent came, that the Gramadan people have been alleging a suppression of their civil and political liberties by the SR government, and they thus have resorted to the power of air strike. Your Excellency, firstly, SR government is a democratically liberal democratic country, and the government here is democratically elected. For just for the example of SR government, Chais Fora, the political leader of Gramdan communities, imprisoned by the
Okay,
government.
listen to me, agent. You're going towards domestic issues. All right. See, you want to do an election, do it the way you want. But please do not state this before the ICJ. I mean, please stick strictly towards international law issues. I mean, this is your internal issue, and it's perfectly all right. You can, but just don't raise this before the ICJ.
Apologies, Your Excellency. The next point is the violation on the basis of humanitarian ground and the ethnic cleansing, which has been mentioned as a genocide. Your Excellency, the agent wants to clarify that the Hurutu evangelist group, as mentioned in the 7th paragraph of Moot problem, the respondent has failed to understand the word evangelist, that it is not being authorized by the SR government, and just their UNSC has already not seen any seriousness in this, and thus has vetoed the draft resolution provided by the respondent country. And thus the agent here clearly that there has been no administration and there has been no funding to the Hurutu evangelist group, also known as Hurutu Orientalist Congress, that they have been alleging the accusation of genocide on the government of SR. It is the matter that would be taken in the by the SR administrators, and would be, but it should not be a concern for the PDRS, because the Hirutu Evangelist Group is not an authority, and it would be punished by the SR government. The last point that the respondent has mentioned is about to maintain and restore peace that's why they have on the basis of humanitarian ground they have attacked on SR government, and then the when UNSC has approached to the approached for the emergency session for America and Russian Federation. Clearly, Your Excellency, that is the last thing which the agent did and the applicant country did. They have resorted the power. They have done after even not getting the permission, they have resorted with full with an airstrike. But the applicant on the other hand has not resorted any power. Rather, after getting denied, after getting vetoed by the draft resolution of UNSC, it came to ICJ for the proper justice. Your Excellency, and thus the agent wants to clarify here that the resortment of power has been done by the PDRS. The jurisdiction is in this court is applicable under section 36 clause 2, under the 36 clause 2 A, B and C points, and that the PDRS has and that the PDRS, the officials of Scythian Republic, has not committed any ethnic cleansing on the Gramdan people, and PDRS is falsely accusing the SR government. The agent also would like to plead here that the PDRS, People's Democratic Republic of Suba, is liable for the attack on the Scythian territory, and as they have clearly mentioned that the embassies and the GAL were in the question, and the GAL was a clear group of the PDRS, so they must be punished for that. Hereby, the agent would like to rest the case.
Okay, sure. Sir, rebuttal from the respondent.
According to the first point, which was spoken by the applicant side, that the PDRS has attacked and it has mentioned that it does not come under the jurisdiction, which I have already proved with 2 cases which has been passed out by ICJ. Second, when the applicant called about the Vinny about the media, so that has been already pointed out by the judge. And second, it has and it has been stated it comes under the public administrator. Then third, resorted the use of force on SR. So as the applicant has mentioned on her own, there was a violation, but it cannot be called a genocide. So violation means the human right violation which was taking place. And about the airstrike, so and about the sovereign was not taking any steps, so sovereign should have taken step while the PDRS attacked. So what was happening, because the first right, the first regret and the first express of regret, and the minority community started showing the SR community was SR territory was on September 3rd, 2020, and the government could not do anything till October 1st, 2020, and it was already the official statement was passed out by
that
the.
is still, like I've said before, inefficiency of the SR Republic, and even if genocide is committed, you can certainly complain before the United Nations Security Council or the treaty bodies which are established, which both your countries have ratified, or you can even come to us, the International Court of Justice, stating that there is a violation of genocide, and the International Court of Justice will deliver a judgment and the peacekeeping forces will be sent. But this still does not justify you taking action by yourself. I mean, this is sort of equivalent to an individual citizen taking action just because the police in their country are unable to act. I mean, I'm just giving this example to you for ease of understanding. So the use of force has still not been proved from your end. So I don't know if you have something to say about this. I mean, they could
Yes.
have certainly committed genocide in their country, but the use of force is still not justified from your end, unless you
Yes.
justify it through some legal evidence. But okay, yeah.
So, sir, these were the points which were put by the applicant side. So, I would rest my case here.
Therefore, the pleadings come to an end, and now we would request all the parties to leave. The results of this match will be announced very soon. We hope that you have access to the table, which is a Google Drive table, which actually shows the points table and everything. Selected participants for the qualifiers in the final of IGMCC will be mailed with a Google Meet invite very shortly. Till then, please wait for at least 30 minutes and the result will be intimated shortly. Thank you so much all.